Good evening, this is Rahul Reddy. Today we are live here from Houston, Texas, every Tuesday from 5 to 6 p.m. Central Time. Emily, what do we have to discuss today?
All right, we're getting a lot of questions from people who are on non-immigrant visas who want to know, can they rent out a property on Airbnb or Vrbo? Can they lease their car out on Turo? I didn't even know what that was. So we want to discuss, is it legal for someone who's in a non-immigrant status to do that and get the income from it? We also got an update from USCIS about the Acics accreditation issue and how they're interpreting that, how it's going to impact students currently at those schools or students who already graduated from those schools. We want to give you a little more automatic visa revalidation to travel to Canada or Mexico. When can you use it? What should you use it for and how to use it? And we also got some updates from the Department of State through the American Immigration Lawyers Association on what's going on with visa processing, what's going on with Dropbox. Are they going to be extending the Dropbox options beyond this fiscal year? So we wanted to give you all the latest on that and, of course, answer your questions.
One thing, Emily, can I do an Airbnb or Vrbo? It seems to Vrbo is the same as or Turo. Turo is very similar to Airbnb, but you're renting your car out. That's what I was being told.
Apparently you can do that with your pool too. I don't know the name of that one, but you can rent out the pool in your backyard if you wanted to.
Oh, I didn't know about that, okay.
So yeah, the issue becomes, if you're on an H1B, you're only authorized to work for your H1B employer. Is renting out a property on Airbnb, Vrbo, renting out your car on Turo, renting out your pool on whatever website that is that considered unauthorized employment? Are you allowed to do that? And we had quite a lot of discussion about it in our attorney meeting this morning. We all had differing opinions. With Airbnb, you're renting out a property or even just a room. How is that any different than buying a house and renting it out yourself?
First, I want to tell the answer to the people. The answer is no. You cannot rent it out. And if you're a non-immigrant visa like H1B, L1, and you don't have any other work permit, you cannot do Airbnb, Vrbo, Turo, or whatever the pool renting, what Emily was telling. I don't have a pool, she has a pool. So it's not allowed. And good question, Emily. What you're asking now is what?
Yeah, so how is Airbnb, where I'm renting out maybe multiple weekends over and over again, and Airbnb is cutting me a check, how's that different than me buying a rental house and renting it out myself for a year?
Well, when you're renting out for an year, Emily, it is considered to be that you are actually giving the property rights to that particular individual for a period of 1 year or 6 months, whatever that period is. When you're renting an Airbnb, it's temporary, very short term though. And there is a lot of work involved in the Airbnb. I have been in a rental home. I have been in an Airbnb. So my experience with Airbnb is that where is a switch? Where is a fan? Where is this one? And it's constant. And whenever I move from one Airbnb, then I go to another Airbnb, it's constant. And there is a lock that keeps changing. Somebody need to manage to clean that thing out. Oh, I'm not going to check out at 11 o'clock. Can I check out at 1 o'clock? They're going to charge me extra. And not only that, every time when I rent an Airbnb, the owner has to say, is it okay for me to come there or not? So there's a lot of work involved in it in the Airbnb than compared to renting a house. Renting a house, we already said many times that if you just want to own a house and rent a house, we don't see that as a problem at all. We don't see that as considered as a work. And also in the Emily, and the thing I found out was that when I digged into it, is that when you look into the website of the Airbnb though, it says that they're going to give a 1099. What is that, K? So it's like an independent contractor that they're going to give it. And when I looked into the instructions, they read it that you are a U.S. citizen, or you are a U.S. resident alien, or operating on entity organized by a U.S. under laws of the U.S. So it does not leave room to the H1Bs or such kind of people that can do the Airbnb. Now, they may not be checking this. The Airbnb may not be checking it. But I think so at a later date, we may get into a problem because when we present the 1099s, that becomes a problem. My question to you, Emily, is that why is a 1099 a problem? Because when you said to the audience before that if you invest through Fidelity or TD Ameritrade, or nowadays what they call it as Robinhood, and when there is a profit there, they get a 1099. Why is that a different?
Yeah, I think there's different types of 1099s. There's a 1099 dividend or DIV. That's what you typically get from your stock investing. And with that, you've clearly not done any work other than passively putting your income there and passively taking whatever dividend they issue. So that is allowed, but with these Airbnb, you're getting a 1099 MISC, miscellaneous, which is basically an independent contractor. That's the same thing you would get if you were hiring a painter, and that painter was coming to your house. You're not employing the painter as the employer, but they're an independent contractor coming to your house. They're going to get a 1099 for the payment. So that's definitely work when a painter comes and paints your house compared to putting money in the stock market.
Emily, what if the person is an H4 EAD or adjustment of status EAD as a dependent? Do you see any problem there?
No, I don't see any problem with that. So the restriction is if your visa is tied only to a specific employer, where you're only allowed to work for the company that sponsored you and only under the terms and conditions of that visa, you cannot do this. But if you have an EAD, whether it is H4 EAD or the green card EAD, you're unrestricted at that point on the type of work that you can do, as long as it's legal work.
Emily, on the Airbnb website, it says resident alien. Do you still see any problem though?
Yeah, so the resident alien doesn't refer to someone who's just a resident, i.e. living in the U.S. It has a specific term, and they're talking about green card holders, EAD holders, not someone who is here on a visa. And I'd also mentioned STEM, OPT, and OPT. Those are EADs, but they're not allowed because those are only it has to be directly related to your degree.
Emily, do you see, what if the main applicant has an EAD, AOS EAD, Emily, and then he's having the main job as let's say he's a software professional. Can he do this Airbnb or even Uber, for example?
Yeah, if you have your main job that's supporting the green card that you were sponsored for, you've moved that to a new employer under AC-21, and you're still going to do that, you can use your EAD to do a side hustle. No problem with that, as long as you always have a job offer that supports the green card process.
Emily, we just learned that, any other discussions before we get to the next? Emily, we just learned that ACICS, the accrediting agency that accredits the university, lost its accreditation. I mean, that sounds weird.
Yeah, the accreditor lost its
accreditation. Can you explain what it is, and we can go into the discussion?
Yeah, so this is the organization that is giving accreditation to different colleges and universities in the U.S. A lot of these day one CPT schools have been historically accredited by ACICS, and it started running into problems with the Department of Education, which was saying that you're not overseeing these schools properly, you're not looking into what the schools are doing. We're going to question, should you be able to continue to accredit these schools? They kind of pulled it away, and then the Department of Education kind of brought it back for a while. Well, now, officially, as of August 19th, 2022, ACIS is no longer eligible to accredit these schools. So schools have lost their accreditation that had been relying on that. And that is going to be a major problem for F1 students who are currently attending those schools, F1 students who already graduated and have their OPT to be able to extend the STEM OPT, people who are filing in the H1B master's cap who graduated after this date, and people who are using this degree for their I-140. All of these are impacted if you graduated from one of these schools after August 19th, 2022, or if you graduated before August 19th, 2022, but you're on your initial OPT, you will not be able to get the STEM extension unless you already had your I-20 for it before August 19th, 2022.
So if your university is accredited by ACICIS, and if you are on OPT and STEM extension, you need to contact a lawyer immediately. That's one thing that you need to do. Emily, what is this Margarita switch though? I get a lot of these questions. People who are on L1 visa, H1 visa, H4 visa, they get the H1B visa. Let's say, for example, they are working for a company called AT&T. Now, from AT&T, they want to move to Verizon. So they're working on H4 EAD with AT&T. They got a H1B with Verizon, but they actually now they don't want to work for Verizon. They want to go back to AT&T, and they're on H4 EAD. Is there something like a Margarita switch? You just go and have a Margarita and switch to H4 EAD, because the process that some people describe is that you have to apply for a change of status again from H1B to H4, and while the process is going on, they can't work with AT&T because H4 and EAD is not active. Somebody said that you can just go and have a Margarita and it automatically switches to H4.
Yep, absolutely.
Are you sure?
Yes.
I know you like Margarita, but I didn't know that. Okay.
Yeah, this automatic revalidation, we call it the Margarita switch. It is perfect for this situation where you have an approval notice, and most importantly, you have to have an I-94 in one status that it's not expired, and the I-94 in the other status that you changed to. And if you want to go back to your prior status, let's say you were in H4 with an EAD, and you got the change of status to H1B, and now you want to go back to H4 and use your EAD. Instead of filing a change of status to H4 and waiting months and months for the I-539 to be processed, because you have a valid H4 I-94, you're just not in H4 status, you can exit for less than 30 days, go to Mexico, stay there, have a margarita. When you're coming back, even though you don't have an H4 visa stamp in your passport, you can use an old visa stamp that's expired or in a different category and show your H4 I-94 and be let back in H4 status. And then as long as your EAD has not expired, you can take back up the H4 EAD. Same thing works if you were in L1 and got switched to H1B, but then changed your mind and decided, you know what, I want to keep my L1 longer. You can use the Margarita switch to get back to L1 as long as the L1 has not expired.
So you're telling that I can go to, and I don't have the visa stamping for H4, it expired. And my I-94 is valid for H4. Of course, I got a H1B. I can still go to Mexico and come back.
Yes.
Is that what you said?
Yes. Automatic visa revalidation means you are revalidating an old expired visa or an old visa that's in another category just at that moment when you're entering the US. They pretend that you have a valid visa at that moment because you have the I-94, and once you're in, that fake visa goes away and you don't need it anymore because you're back in the US.
Can I go to India and come back?
No, this only is for Canada or Mexico. We mentioned Mexico a lot because in many cases you don't need a visa to get to Mexico. Canada also works, but you do often need a visitor visa to get to Canada. So you can choose either, but it's got to be only Canada or Mexico. Your trip has to be for less than 30 days, and you did not apply for a visa, a U.S. visa at the consulate in Canada or Mexico while you were there. If those apply and you have a valid I-94 for the status you're coming back to, then you can use this in order to change your status. The one area where it also does not work is to get back to F1. For example, if you were on OPT, EAD, and now your H1B got approved, can you go back to OPT? No.
No. The civil system kicks you out. Once the civil system kicks you out, you cannot come back on F1. That's one reason. The second reason is that your intention for F1 should be only to temporarily enter into the United States, and after completing your education, you have to return back. So when you already have a H1B or any other visa that is approved, you're coming back on F1. That might be a problem too. So we recommend definitely not to do F1.
Yeah, other ways that this can help is you don't necessarily have to be changing from one category to another. What if you are here in H1B status and somehow you fell out of status for some reason, and in order to get back into status, we're not talking about unlawful present here where you're overstayed anything. Here you have the valid I-94, but for some reason you fell out of status. You can travel to Canada or Mexico, have a margarita, come back on that valid H1B and get back in status. It basically cures a lot of prior violations that will then allow you to proceed to the adjustment of status without having any issues.
I want to take the words of what Emily said it, but I just want you to consult a lawyer before you take any of the steps, so if there is any status violations. Some of the simple things that I will tell you about status violation, but I still want you to consult a lawyer very strictly, is, let's say, for example, your LCA is from Florida, and hey, here is the COVID comes in and you come and stay with your wife, and you're actually working in Dallas, and you don't have an LCA from Dallas. That is considered to be a status violation, though. Now, how to cure it, how to go to Mexico in those particular circumstances, please speak with a lawyer before you do that. But yes, there are ways. And Emily, sometimes somebody said that by going to Mexico, having a margarita, it's like a holy grail. You actually clean up all your sins. We in India call it as taking a dip in the river Ganges. All your sins are washed out. Is that possible by having a margarita?
Yeah, it does fix a whole lot of them. It doesn't cure everything, but there are a number of things that can be cured to allow you to get back into status and also be eligible for adjustment of status later.
So, for example, if I have been working in Dallas, I don't have an LCA, and I never leave the country, and I apply for the green card, there is a problem there? What's the problem there?
Yeah, because in order to file adjustment of status, you have to show that you properly maintained your non-immigrant status up to the filing of the 485, from the day you last entered to the day you're filing the 485. So if there's any violation that occurred in between that puts you out of status, now you're not eligible for adjustment of status. But if you have traveled and come back in, now we've changed the time frame that we look, and you came in after the status violation. Now it doesn't exist anymore for purposes of being eligible to file the adjustment of status in employment-based category. This does not work for every single type of adjustment of status, but for employment-based, there's a special provision called 245K, which makes this work to travel to cure a violation, come back in, and be eligible to adjust status.
So this Margarita switch is switching the visa status from H4 to H1 or vice versa, and L1 to H1 and H1 to L1 and vice versa. And also it cures, it's a holy grail to, it's drinking like the water from the holy grail, which cures a lot of problems. And like what we say in Indian culture, it's called as dipping yourself in the holy Ganges to some extent. However, for the status violation people though, we strongly recommend do not take that step of going and having a margarita before you speak with a lawyer. Anything else, Emily, before we go to the next topic?
No, I think we're good.
The great news. What's going on? The visa processing of the Department of State. Seems that we got very good news now.
We did get good news. So number one is, so we currently have the interview waiver program, meaning Dropbox. So Dropbox has been expanded until the end of this fiscal year, or until December 31st. And based on COVID and all of that, in order to allow the consulates to adjudicate more visa applications, they're waiving the interview for many people. They have decided, but they have not implemented it yet, but they are planning to make it effective all the way through fiscal year 2023. So the interview waiver expansion, where if you've gotten any kind of visa in the last 10 years, you don't have to automatically go for an interview the next time you're applying for your visa. That's going to be expanded through the end of fiscal year 2023.
That means until September 30th of 2023.
Yes. They are actually encouraging people to go to other consulates. If your consulate does not have appointments available.
What do you mean? I can go to, they're encouraging me to go to Vietnam because US consulates in India are busy?
Yep. They specifically said posts, meaning consulates, are open for business. And they have been instructed to take applicants from outside of their consular district, even those where third country national is normally not an option because of intent issues, like
so
a
you said
tourist
previously visa. That third country nationals mostly are only promoted in Mexico and Canada. So now you're telling that the Department of State is telling something different.
Right.
That means people can go to not only Mexico and Canada, but also to Vietnam, because some of the Indians are going to Vietnam because they don't need a visa to go to Vietnam.
Yeah, anywhere you can get to without a visa, or anywhere you can easily get a visa and you can get an appointment for your US visa, you can now pretty much go anywhere. They're going to be working on updating that visa wait time website to also include Dropbox wait times, and also even to point out which posts are open to third country national processing.
Oh, that means when I go to making the appointment, they'll say, hey, Vietnam is coming up first.
Yeah.
Okay.
Yeah, other interesting things. So with everything that's been going on with COVID and these interview waivers, they've actually been remotely processing these visa applications from inside the US and also using other consulates. So when all the consulates in India were crazy backlogged and you couldn't get an appointment, or they were trying to process these interview waiver applications, they may have been having people from consular officers from Tokyo handling that case, or even officers in the US handling those cases. And they do seem to be planning on continuing that because they're basically, when COVID happened, they lost a lot of their fees that they used to continue to employ all of their staff. So they cut staff. They had hiring freezes, so they had no new staff. Now that things are up and running again, they had to hire new staff, but that new staff is not trained yet or ready to be deployed. So they're basically saying, I think, that the low staffing levels are likely to continue throughout until the end of the fiscal year. They'll be back to pre-pandemic staffing levels by the end of fiscal year 2023, so next September. So that's good, but it's slow progress. They also, though, mentioned that they are still looking into the stateside visa renewals of doing those inside the U.S. like they used to do pre-9/11. You know, they've talked about their openness last summer, and we've been kind of pushing them and saying, when is this happening? A lot of people were expecting it to happen quick. Do not expect it to happen quickly. They are still looking at doing it, but what they're saying is the whole process needs to be set up from scratch. They don't know how to get the payments. They don't know how to print the visas on the passport. They don't know how to get who's going to be adjudicating these. Now, I think all of that is bull, because they just told us that they have all these officers in the U.S. who are remotely adjudicating visas in India. So why can't they just use those same officers and mail your passport here?
Because they're working from home, Emily. They don't work from Washington, D.C.
Yeah, but they also they don't know how to process payments. That's the whole CX system, the DS-160. You take payments every day in that. Why does it need to be a new system?
Go to PayPal.
Yeah. And they are... another thing. So they're trying to basically prioritize legitimate travel. And, you know, a lot of people are complaining about not being able to get an appointment. And they're basically saying that the people that are in the U.S. are not a priority to get appointments. They're
already here.
Exactly. Their priority is the people who are outside the U.S. waiting. Other than tourists, they're not prioritizing tourists. But anyone else, student visas, work visas who are outside the U.S., they're starting to prioritize those first. And then those that are already here are kind of at the bottom of the list. But hopefully we'll see improvements, and the ability to go to any other consulate, I think, will definitely be a help. Lastly, you know, there's been a lot more administrative processing where basically, even for just a routine visa, they're just saying, we can't adjudicate this yet. We haven't finished all of the administrative processing. Apparently they weren't aware that this was happening or that there's been an increase in it, so they now are looking into it and trying to resolve the issue. But it might be 2 months before we see administrative processing issues being improved. So at least there's a dialogue there, so we're getting more information, which is helpful.
Let's go to the question that answers. Sindhu's question. Does compounded and closed 498A dowry case in India be an issue of adjustment of status? What are the approval chances? Yes, Sindhu, it is better that you consult a lawyer. It is better be a lawyer who is actually licensed in India and also here. In our office, there are two. I'm one of them. You can consult me and I will discuss about the options. I'm pretty aware. I'm a licensed lawyer in India too. Rang from YouTube has this question. Can my spouse on H4EAD ride Uber? Yes, absolutely. Riding is not an issue, guys. Taking a Airbnb is not an issue. The issue is if somebody is actually doing the Uber, doing the Airbnb without having an EAD. Those are the issues. You want to take a ride? I mean, you can be an H4, you can be H1, you can be anything. You're good, absolutely fine. You don't have a problem with that.
Pramanth says, will the EB3 rest of the world unused visas spill over to EB3 India? Considering that the I-140 inventory for EB3 rest of the world is less compared to EB2 rest of world. To some extent, yes. We were actually looking at the numbers pre-COVID for the last 5 years before COVID. EB3 India actually received more green cards each year than EB2 India. And it's because there was fewer rest of world EB3, which allowed those to be utilized by India. Now, is the difference going to be huge? No. It was about an average of 4,000 EB2 green cards a year compared to 5,000 EB3 green cards a year on average. But yeah, that is definitely a possibility that EB3 will end up getting, EB3 India might end up getting more green cards than EB2 this year.
A question from Sanjeev Kumar. A property dispute type of law situation in India, does it affect the green card process? No, it does not. Property disputes in India is not going to affect your green card. I'm a lawyer in India too. So no, it does not affect your green card process, H1B or your stamping or anything. It's a civil dispute, so you're good.
Gokul says, is there a 60-day requirement to find employment in the case of a job loss after 180 days of the 485 filing? So the 60-day requirement is a grace period, but it specifically applies to the non-immigrant work visa. So if you are wanting to continue to be an H1B after the job loss, then you need to file your H1B transfer within 60 days, regardless of the 180 days for the 485. They're two separate rules. So is there a rule saying you have to have the new job within 60 days for the 485? No, but the whole 485 is based on an offer of employment. And so if at any point USCIS sends a request for evidence for a supplement J, or you get called in for an interview at a time when you do not have a valid offer of employment, that can cause the 485 to be denied. So definitely if you're in the situation where you're experiencing long-term job loss while your 485 is pending, you should speak with a lawyer on that to understand how that impacts your case.
Emily, when we are having a debate in the morning with 15, 16 lawyers in the morning, and we like to do the presentation after we have our debate in our office, which we normally have a staff meeting of lawyers, guys. So Emily, you were discussing there are some creative ways that, let's say, for example, I'm an adjustment of status, I'm the main applicant, it's been 6 months that I've worked with this particular company, I lose the job right now, and I don't get a job. What are the solutions? I know they're risky if I don't have a job if I don't have another job. What are the solutions, that creative arguments we can come up with?
Yeah, I think if it happens to coincide when USCIS is asking for a supplement J to confirm that you have a job offer, or you're being called in for an interview and the prospects are not looking good that you'll have that job offer, self-employment is an option for AC21. So if you want to start a business that it's in the same field that you were actually working in, and you get that up and running, you get your tax ID number, you open the bank account, you start a website, you could potentially use that. Your business, your own business, can be the company that signs the supplement J for you. Now, you need to have legitimate plans to get it up and running, but it doesn't have to be like already successful by the time you're submitting that supplement J. You need to show that you have plans in place and it's a work in progress.
Did you anytime had to face a USCIS interview on this particular issue?
Yes, yeah. We used this at an actual interview We actually, before the interview, submitted the Supplement J, but it didn't make it into the file that the officer had. So we brought it again to the interview, asked very few questions about it. We had all of the documents ready, no issues at all.
However, I would be very cautious on it. If you want to take any of those steps, please consult a lawyer though, because these are risky steps. I would like you to have a continuous job offer at all points of time. And sometimes the USCIS will ask the employment history from the past 5 years. They ask you to submit a form called G325, asking 5 years employment history, especially when the adjustment of status is for a long period of time. And there, if there is a self-employment, it really rings the bell for the USCIS. It's going to unnecessarily cause it. If you can avoid it, we would recommend that you avoid that.
Madan says, what does case transferred to another office mean for the 485 case status? It could be a number of things just depending on what the situation is of your case. For example, if your case was pending at the Texas or Nebraska Service Center and it says case transferred to another office, it very likely means it was transferred to the National Benefits Center, since they started doing those transfers in 2021 in order to speed up the processing. So that's one option. Or if your case is already at the National Benefits Center, it could be that it's being transferred to your local field office so that they can plan for an interview. That's another option. Also could mean they're transferring it to some other random field office that has the availability in order to process a case without calling you in for an interview. So those are probably the three most common reasons that we see that.
Ravi Raja has this question: can an H1B employee do business while working for a company? We address those issues of the Airbnb, we address the issues of the Turo. They are not allowed. But if you want to invest in some companies, like for example, if you want to invest in Fortune 500 companies, S&P 500 or whatever you call QQQ or VVO or SPY, absolutely not a problem though. When you are telling do business, that means that you're actively involved, Ravi. No, you cannot be actively involved in a business. My suggestion to you, software guys, believe me, if I would have all these situations where I'm going to go and put $100,000, make $1 million in Airbnb, and guess what, Rajiv, Ravi, or rest of the people, I wouldn't be a lawyer here sitting down, guys. Believe me, I would not be. I would have been making millions of them. Now, what you have, the best solution that I would suggest you is, most of you guys who are listening to my to this YouTube or Facebook is probably software professionals. I mean, you are the highest demand sought over in the entire history or the entire world exists. The only time I feel there is anybody else who is in more demand is soldiers at the time of wars. They are in high demand than you software guys are, because when there is a war, I would pick a soldier rather than a software guy to go with me. That's the only time you are the next to that guy. I mean, you're in high demand. You guys can work multiple jobs. A lot of people are wondering, wow, I can only work for one employer. No, you can work for multiple employers. You can have one employer. Let's say, for example, you're working for AT&T. You want to work for the second employer, you can. You don't need to, in immigration law, you don't need to inform the first employer that you're working with the second employer. But the second employer need to file a concurrently filed H1B. And people ask me, can I work for 3 employers? Yes, you can. My wife works for 6 employers on W-2. Nothing wrong. Well, she's a US citizen, but there are provisions. I have filed for some people 5th or 6th employment on H1B. These are dentists, doctors that work for 5 or 6 companies. Sometimes only work 2-3 hours for an employer. That's allowed too. Sometimes some of the people work 2 40-hour jobs. And people ask the question, can one employer, let's say you're working for ABC Consulting Inc., can he assign you multiple clients at the same time? Absolutely he can. Absolutely he can. So those are things that you can discuss with your employer. If it's a flexible employer, or discuss with other people. Yes, you can.
All right. RK says, I have an H-1B approved for a new company and wants to know, if I decide to accept a different offer from another company, do I have to provide this new H-1B approval that I got? So you just filed a transfer, got it approved, and now you want to file another transfer and want to know if you have to provide that approval notice to the second employer. If you never joined the first transfer company, no, you do not need to provide that approval notice.
Do they have interviews for EB1C now? Senthil, I would say for EB1C though, 95 or 90 to 95% of the people do not get interviews. There are 5 to 10% of the people who get for the interviews for the 485.
Ashish says, can the medical form signed by the civil surgeon in June 2022 be used to submit the medical RFE issued in October 2022? Currently, yes, that is an option. So if you obtained your medical after filing the 485, it's valid for 2 years from the civil surgeon's signature. If you got your medical before filing the 485, the rule used to be that the medical expires 60 days after the civil surgeon signs it, unless you submit it. So you have to submit it within 60 days if you got it before you filed the 485. But that is currently not true. They took the 60-day rule off. So as long as the civil surgeon signed within the last 2 years, you can submit that.
Can you apply for H4 EAD plus H4 change of status while an active H1B that's maxing out next year? Absolutely yes. And please don't go to the last 2-3 months and apply at that point of time. You better apply right now. And while the H4 and EAD is pending, you can work. And please file H4 and EAD together. Don't file it separately. If you file it separately, H4 will be approved first, then you have to stop working, then the EAD will be approved. If you apply together, they will be approved at the same time. So you apply for H4 plus EAD, it's maxing out next year. Whenever the H4 EAD comes in, you just move on to H4 EAD. Question from SNH. Can we respond to the RFE directly without involving lawyer? It's just medicals, employer letter plus tax details. The answer to you simply is yes, but my recommendation to you is no, do not do it. We at Reddy Neumann PC only tell people to respond to the RFPs if by themselves, only when it is medical. Anything else other than medical, do not respond. Go through a lawyer, because you're speaking about employer letter, tax details. What tax details they are speaking? That's really complex. Definitely do not recommend that you do that.
Nitin is currently in the US on H4 without an EAD, has an H1B that was approved back in 2017 when he was in India, and wants to know if he can file a change of status from H4 to H1B. In this case, never got the visa stamp with that H1B approval, never entered the US on H1B. And because of that, the answer is no, you're actually not considered to be counted in the cap. You have to go through the lottery again because you never entered on H1B and you never got the visa stamp. In those situations, a consular processing H1B approval is not counted in the cap, so you'll be subject to the lottery.
Puneet from Facebook has this question. Automatic revalidation, is it allowed for travel, for aid travel as well? Absolutely yes. In fact, when you want to do some things like, for example, 540 days extension and certain things, we strongly recommend only air travel. Especially don't go to Laredo, guys. I mean, they are tired of us and they are not doing the proper Margarita switches when you're going and traveling outside the country. And also they're not extending the things for the H4s that we normally recommend people to go by carrying their spouse's H1B up, which is already approved, to get their H4 EAD extended by 440 days. Yeah, air travel is strongly recommended. Shashidhar Reddy has this question from Facebook. My priority date is August 2014, applied 485 in April of 2022. I was scheduled for interview this month. We are noticing this a lot, and a lot of people are asking, my priority date is not current. They cannot approve the green card. Why are they interviewing you? Yes, they are interviewing people. It's very common because they want to see, what if you are a murderer? What if you are not eligible for the 485? They don't want to keep on continually giving you the EAD approvals to you. So they do interview people even if the priority date is not current. You have to take it very seriously. And there's a video we put in on AOS interview. So you may want to watch it and go through that video before you go for the interview.
Tenant Priya says, my husband filed the I-130 for me. My current status is the GC EAD and parole based on the employment based, and wants to know, after the I-130 is approved, am I allowed to file the 485 based on this family based, or is my only option consular processing? So assuming that, like you said, you are not maintaining a non-immigrant status, you're relying on your employment-based adjustment of status using the EAD or AP, you're not eligible to file another 485 based on the I-130. You can only consular process at that point. And the reason for that is, in order to be eligible to file any 485, you always have to demonstrate that you're in a non-immigrant status at the time of filing that 485. So since you fell out of non-immigrant status, you are not eligible to file a second 485.
Pramod has this question that H1B maxes out in December 2023. He plans to get married and December 2023. And what are the chances for the H4 plus EAD to be approved in 9 months to continue working here? Very good chances. But my question is, if you have decided to get married in March, why not get it right now? That's even better. That's my advice. 9 months, you have about 80 to 90% chance to get the H4 plus EAD.
Sushmita says her H1B was approved in premium, but still hasn't received the approval notice from USCIS. They raised the service request and the wait time is 3 to 6 months. Is it okay to transfer to a new employer without the I-797 copy? Yeah, we're seeing these delayed approval notices a lot right now. The service requests are going nowhere. It's very frustrating. Now, yes, you can file a transfer and provide, if you have the receipt notice, and then provide the online case status showing that it was approved, you can get the transfer filed. You may get a request for evidence asking for that approval notice later. So it's possible that your transfer won't be approved until you're able to provide that approval notice, unless the USCIS officer, which they should be able to look it up in their system, but they generally don't. They want you to give them the copy. So yes, you can file it, but to get the approval, you may need to provide it to them later.
Pawan has this question. His I-94 expires on January 8th, and his new H1B extension starts on January 23rd. Is that some an issue, or does he need to get a visa? Now, there are two different issues, guys. He's speaking January 8th of 2023. That seems to be a problem to me, Pawan, because your I-94 expiring in June 8th and the next one is starting on January 23rd. That seems to be a problem. Now, when is it not a problem? Please listen carefully, guys. Let's say, for example, if your H1B has expired in August of 2022 and your new H1B starts in September, let's say August 2022, and your new H1B starts in October of 2022, because it was approved in October of 2022, but it was filed way before the H1B expires, you're fine, absolutely fine in that case though. But in this particular situation, he's speaking about the future, that it expires in January 8th of 2023. The new extension starts in January 23rd. There is a gap of approximately around 15 days there. That definitely is a problem. You need to contact your company's lawyer.
Jeet had a pending H1B to H4 application and withdrew the pending H4 during COVID, but it was still approved. The attorney told him to send the approval notice back, and he wants to know, can I still use automatic visa revalidation? No. You need to assume that that H4 has been withdrawn, even if it's not withdrawn yet, because Murphy's Law is, as soon as you want to use that H4, they will issue the withdrawal notice, putting you out of status. You don't revert back to your old status in that situation. So you need to act as if it's been withdrawn and not rely on it. Do not use that for automatic revalidation. Pavan says, my 485 has been transferred to NBC. Does that mean a visa number is allocated? No, 100% no. It does not mean that at all. USCIS confirmed that in their recent update. They do not allocate the visa number until the very end. Transferring to the local office, no visa numbers allocated. Issuing an RFE, no visa numbers allocated. Getting the RFE response back, no visa number is allocated. Just because you got an interview notice, no visa number has been allocated. They do not allocate it until they are ready to hit the approve button.
Questions that come is that if I use an advance parole and if I come back an advance parole, does it mean that my H1B is gone? If your H1B is still valid and the validity period is still there, you are good. You can still extend the H1B. You can transfer the H1B. Absolutely not a problem.
Question about moving from Florida to Georgia and got the interview notice for Florida. Even though you filed the address change, do we need to reschedule the interview? Yes. So even though they scheduled it in Florida, if you live in Georgia and you travel to Florida to go to this interview, they're just going to look at you and say, there's nothing we can do, go back home, we'll have to reschedule. So you can save yourself the trip by letting them know in advance and asking them to reschedule in the right location.
Can you do the change of status back from H4 to H1B once the I-140 is approved? And I've been on approved and I've been on H4 for a long period of time. Absolutely. Once the I-140 is approved, you're already been counted toward the H1B number, even though you may have completed the 6 years period. Since you got the I-140 approval, you can move back to H1B.
Sanjay says, is a child who's on F1 but under 21 eligible to file the 485 as a dependent if their parents' employment-based date becomes current? Yes, absolutely. So it's not required for the dependent to be in a dependent visa in order to file as a dependent on the 485. So your parents can be an H1 while you're an F1 as long as you're under 21 and maintaining your F1 status. When your parents file, you can file.
The people are asking whether there are any stampings available right now within USA for H1B. No, there is no process for that for H1B stamping or any other visa stampings are not available right now.
Krishna says, is there any benefit of becoming a Canadian citizen for EB2 or EB3? No, it is based on country of birth, not country of citizenship. So really the only benefit is, number one, having the Canadian option as a backup plan, but it does make you eligible for a TN if your job offer meets the criteria for that category, which is often a lot easier than an H1B or an L1.
Once my perm is approved and my priority date is current, how long does it take to get an EAD and AP card? Anywhere, once you file an I-140 and 485 and EAD, anywhere between now, the applications recently is anywhere between 2 to 6 months. Now, please, for the applications that were being filed before, it took a long period of time. Some of them even took almost like 17, 18 months. But right now, anywhere between 2 to 6 months is average time.
Should I update my I-9 with my current employer if I started using the EAD to work for another employer? No, you're not required to do that. So even though by working on that EAD, you're taking yourself out of the non-immigrant status, your employer only has to require you to update the I-9 when the last employment authorization document that you gave to them is expiring. So they won't ask you for new employment authorization documents until your H1B or whatever your prior visa was is expiring.
Krishna has this question. I got my green card. How can I get my fiance from India to USA? There is no fiancé visa for the green card holders. So you have to file an I-130. The whole process might take anywhere between 2 to 3 years to bring a person from outside the country. Once you get married though, fiancés are definitely not allowed for the green card holder. The other option is that they can come here on a H1 or L1. And they can, once you get married, then they can file an I-1, you can file an I-130 and 485 for them.
Can you do a change of status back to H1B from an H4
I
EAD?
understand.
Oh, you got that one
Yeah,
already?
yeah.
All right. Do we know who took over for Charlie at the State Department? I've not seen any announcements with a name or
No, I don't.
anything. He does have a replacement, but not getting the same kind of transparency. He's obviously not doing the check-in with Charlie with Ayla anymore, not doing the YouTube anymore.
I think so. It's the deputy who's in charge right now. They still did not appoint a permanent person. That's the way I think about it. A question that came from Sanjay Verma is that the child is under 21 and an F1 visa. If the priority date becomes current, can they still file the 485 even if the child is an F1, not an H4 or L2? Absolutely, yes. They can file the 485 as long as they are under 21. And there's also something called under 21 CSPA. The word is Child Service Protective Act. You may want to look into that video. It's about 10 minutes video. There's a 21, but also there are in certain circumstances. It's called CSPA. You need to watch that video. Please watch that video. CSPA, Reddy Neumann. Put it in the YouTube. You'll get that information.
Abhijit says, if my priority date is current, is there any processing time after which I can raise a service request to expedite my 485? So number one, no, there are no expedites to 485s. Number two, you can raise a service request only when it's outside the normal processing time. So you have to look at where is your application pending, what's your local field office, look up what that 485 processing time is. It's probably 36 months. So if it's been less than 36 months, no, they won't let you even do a service request at all, even though your date is current. You could potentially file a lawsuit in order to get the 485 adjudicated, given the unreasonable delay under the Administrative Procedures Act, but there's not a way to expedite a 485 by doing a service request.
Do such using the EAD and AP by both spouses while wife is a permanent applicant? This question comes from Vatsalya. I have used it. I became an immigration lawyer. I even went to the 485 interviews while I was on the EAD. I did used it, so that should tell you what you should, unless there is something faulty in it though. Unless there is something wrong with your I-140 application, are there any fundamental problems with it, with your 485 application? If I were you, I would definitely use the EAD. Another question comes, Emily, what is his expectation in the December visa bulletin?
Oh gosh. I don't think we're going to see any movement at all.
Why not? There are extra 60,000 green cards that are available right now in this year.
Yeah, so we know there are, I think there are 40,000 EB1 cases already pending, EB1. So there's not going to be a whole lot of extra EB1 falling down.
But EB1 pending could be I-140 not approved. There are always chances of denial of I-140, okay? But still, we're only first 2 months of the year though, okay?
All right, we also have, and I can't remember the number, but it was 30 to 40,000 EB2 rest of world 485s already pending.
That's not Indians and Chinese nationals.
Right,
so if you give 4,000 to Chinese nationals, 4,000 to Indian nationals, that leaves approximately around, that's 8,000, so approximately 50,000 left over, okay? How much you said? 40,000? 40,000 for the rest of the world, only 10,000 are left. Mm-hmm. And then we still have the rest of the year, these rest of the world people can still file the 485 application under EB2. Mm-hmm. So that leaves only 4,000 green cards for EB2, so we may not expect much movements for that. Do you expect the rest of the world to go back soon, Emily? Because that's the big danger. Once it goes back, we're all squeezed up, is that right?
Yeah, I do think. Now, they're supposed to leave that date current as long as they don't have the full amount of 485s for the number of visas available. Even if they're really close to that number, they're still going to keep it current, but it's going to retrogress at some point.
Question that is coming up is that when can the USCIS reject the premium processing when it is pending? We are noticing some of the things where they are telling it's a security check, and they sometimes do that. Very rarely they are doing it right now. Previously, it's different, especially in December of 2020, somewhere that time, the rejection was very high. But nowadays, very rarely we are seeing, but yeah, there are some cases that they're rejecting the premium processing, giving the money back to us.
A lot of people are mentioning that their priority date is current, but the case status is still showing that we're temporarily pausing work because an immigrant visa is not available to you. Keep in mind that they don't change that status of your 485 based on what's happening with your priority date. It only changes when they've actually done something with your case. So it's going to stay that status until an officer picks it up. That doesn't mean they don't know that the date's current. It just means nobody's looked at it yet or taken any action on the case. And again, if you're not outside normal processing time, you can't do a service request to let them know that your date's current. Ombudsman is not really taking any action on these cases because they're just being bombarded with all kinds of problems, and they're only taking on the truly serious problems. So probably a lawsuit might be your best chance on that.
People are asking if the premium processing is not adjudicated in the proper timing, will they return the check? Yes. You have to request the check through email and they will return the check. We have seen that many times. It may take about 3 months to almost 1 year for the check to come back, but they do return the check.
All right, well, I think we're out of time for today. Thanks so much for joining us. As usual, we'll be back next week, and go Astros.
Yep. Go India. Big